Part 3 of the Ordinance, Adjudication of Payment Disputes. When a payment dispute arises from scenarios 1 to 3 on slides 14 and 15, the claiming party can serve an adjudication notice on the upstream paying party and the adjudicator nominating body within 28 days of the arising of the payment dispute. The adjudication notice must state the nature and description of the payment dispute and the disputed amount, etc. Here it is assumed that only one adjudicator nominating body is specified in the contract. The adjudicator nominating body is required to appoint an independent adjudicator to handle the payment dispute within 7 working days. The adjudicator nominating body has established procedures for the nomination and appointment of an adjudicator. During this process, the adjudicator is required to declare conflicts of interest. And the adjudicator nominating body will also seek the agreement of both parties. After the adjudicator nominating body notifies both parties of the appointment of the adjudicator, the claimant has 1 working day to serve the adjudication submission on the adjudicator and the respondent. The adjudication submission may include supporting documents and evidence that the claimant considers relevant to the adjudication. The 1 working day is mainly for the claimant to arrange for the service of written submission to the adjudicator and the respondent. The claimant, as the party to initiate the adjudication, should be able to commence the preparation of the adjudication submission at an earlier stage. The adjudicator cannot extend the 1 working day time limit for serving the adjudication submission. Upon receiving the adjudication submission, the respondent has 20 working days to prepare and serve an adjudication response on the adjudicator and the claimant. The adjudication response may include supporting documents and evidence that the respondent considers relevant to the adjudication. It may also indicate whether there is any information in the claimant's adjudication submission that the respondent was unaware of on the date the adjudication notice was served, and such information should have been served to the respondent before the adjudication notice was served so that the respondent cannot fairly consider and respond to it. If there is such ambush information, the adjudicator should disregard it according to the ordinance. The adjudicator may extend the 20 working days time limit for serving the adjudication response. Within 2 working days after the respondent has served the adjudication response on the claimant shall serve a reply to adjudication response on the adjudicator and the respondent, specifying whether there is any similar ambush information in the adjudication response. The adjudicator may extend the 2 working days time limit for serving the reply to adjudication response. The adjudicator shall make a determination within 55 working days after the date of his or her appointment, including the amount payable by the upstream paying party, including interest, the payment deadline, the adjudication costs payable by both parties, etc. If the payment dispute involves an extension of time, the adjudicator shall also determine the number of days of extension of time for completion of the contract. For complicated cases, the 55 working days adjudication period may be extended subject to the agreement of both parties to adjudication. The ordinance empowers the Development Bureau to establish a register of adjudicator nominating bodies. The adjudicator nominating bodies will be professional institutes familiar with the operation of the construction industry and organizations specializing in handling contract disputes. The Development Bureau will also formulate the main content of the adjudication rules, code of practice and code of conduct for adjudicators, as well as a unified guideline on conflicts of interest to ensure the quality of adjudication. Adjudicators are qualified professionals such as engineers, architects, surveyors, and lawyers with experience in handling contract disputes in the construction industry. Adjudicators are required to declare conflicts of interest at the time of their appointment and throughout the adjudication process. Other matters to note for adjudication proceedings include, first, if the contract does not specify an adjudicator nominating body, or specifies more than 1 adjudicator nominating bodies, the claimant must nominate 2 adjudicator nominating bodies for the respondent to select from. This will take an addition of 8 working days, that is, the adjudicator is to be appointed by the 15th working day at the latest. Second, a working day for the purpose of the adjudication proceedings mean a day that is not a. a general holiday, b. Saturday, c. a black rainstorm warning day or gale warning day. Third, the parties are jointly liable to pay the adjudication cost in the proportion determined by the adjudicator. If the claimant initiates adjudication without a reasonable prospect of success, the adjudicator may order the claimant to pay a higher proportion of the cost of adjudication proceedings. Fourth, the adjudication mechanism is not yet applicable to payment disputes involving extension of time (EOT) under main private contracts and their subcontracts. Construction contracts generally allow the construction period to be extended in cases there are delays not at the contractor's fault. For example, changes in design by the employer, delays in site access for the contractor. These situations are commonly referred to as EOT claims. EOT claims are usually accompanied with claims for losses and expenses incurred due to the extended construction period. Generally, adjudication of payment disputes associated with losses and expenses arising from EOT claims is more complicated. Given that adjudication is a new mechanism for resolving payment disputes in the construction industry, and it takes time to train up adequate number of experienced adjudicators, adjudication of payment disputes involving EOT will be implemented for construction contracts procured by public organizations only, that is the government and specified bodies in Schedule 3, in the first phase of implementation, after consultation with the task force. This arrangement allows the government to comprehensively evaluate the implementation of the ordinance and where necessary improve the adjudication mechanism based on the experience gained. Once the adjudication mechanism becomes well developed, the Secretary for Development will specify an effective date to extend the application of the adjudication mechanism to payment disputes involving EOT arising from private main contracts and their subcontracts. To ensure the quality of adjudication, the adjudicator nominating body is required to prepare the following documents related to adjudication proceedings, including adjudication rules, which is to make rules for the conduct of adjudication proceedings. Practice notes, which is to establish best practices and/or standard of adjudication proceedings. Code of conduct for adjudicators, which is to establish the standard on the professional and ethical responsibility of adjudicators, for example, maintain independence and impartiality when adjudicating the payment disputes, avoid conflicts of interest, uphold the duty of good faith and competence, etc. Guideline on conflicts of interest, which is a standard for assessing whether adjudicators have conflicts of interest. The Development Bureau has formulated the main body of the adjudication rules, practice notes, and code of conduct for adjudicators, which adjudicator nominating bodies must comply with when formulating these documents. In accordance with the powers conferred by the ordinance, when an organization applies for registration or renewal as an adjudicator nominating body, the Secretary for Development will review the adjudication rules, practice notes, and code of conduct for adjudicators prepared by the organization. If the submitted documents do not meet the relevant requirements, the Secretary for Development may not approve the registration or renewal application. The above administrative arrangements ensure the consistency and effectiveness of the adjudication rules, practice notes, and code of conduct for adjudicators for different adjudicator nominating bodies. The Development Bureau will also formulate a unified guideline on conflicts of interest for use by adjudicator nominating bodies. A determination is binding on the parties unless the payment dispute is settled by written agreement between the parties or determined in arbitration or court. The respondent must pay the adjudicated amount by the deadline specified by the adjudicator. The payment deadline for the adjudicated amount is, a. the deadline specified by the adjudicator in the determination, or b. if not specified by the adjudicator, within 30 days after the date on which the determination is served on the parties. The respondent may apply to set aside the adjudication determination pursuant to Section 48 of the Ordinance, but it should be noted that the circumstances in which the court may consider setting aside the determination are only limited to a. the determination was improperly procured through fraud or bribery, b. there has been a material denial of natural justice in the proceedings, c. the adjudicator has not acted independently or impartially in the proceedings, or d. adjudicator has acted in excess of the adjudicator's jurisdiction in the proceedings. In other words, a party to adjudication cannot apply to the court to set aside the determination simply because he is not satisfied with the determination or believes that the adjudicator has erred in making the determination. If the claimant does not receive the adjudicated amount in full by the deadline specified by the adjudicator, the claimant can exercise the right to suspend or slow down the progress of work or supply. The claimant may also apply to the court for enforcement of the adjudication pursuant to Section 49 of the Ordinance. The court will decide whether to grant or refuse the enforcement application within 14 days, or a longer period that the court considers appropriate, after the date on which the application is made. With the leave of the court, the determination can be enforced in the same way as a judgment of the court.